had a website designer. And she said, I don't want to make a website for same-sex marriage. We had the case from a couple years ago, Masterpiece Cake Shop, involved a baker. And that case sort of got resolved on religious grounds that are kind of unique to the case. But here we had a designer for a website, right? Is a cake speech? I'm not sure. Is a floral bouquet speech? I'm not sure. Is a website speech? Yeah, it is, right? You're literally putting words on a page with graphics. If that's not speech, I don't know what speech is. Okay, so why does this matter, right? Why does this case matter? It wasn't entirely clear that anyone ever asked this woman to make a website. And as you know, in court, you can't bring generalized grievances. You have to have at least some injury, some basis to show that you're going to have to get something to be addressed by the courts. What made this case unique, though, was that the Colorado government more or less stipulated that, yes, we have this law, and yes, we might prosecute for it, right? The Colorado government more or less agreed that this woman had standing. Why? I couldn't tell you. That seemed to be very strange lawyering. So when it got to the Supreme Court, people are throwing their hands up saying, this woman's making up a case. It's a phony case. It's a bogus case. All right, well, look, if you're a litigant and you stipulate the things, those stipulations can be used against you. So the standing analysis from Justice Gorsuch's opinion relied almost exclusively on these stipulations, which, look, they're in the record. You make a stipulation that that's the facts you got. So I think in the abstract that you have standing, I'm not sure. But based on how the case was litigated, it was enough to get standing. Okay, so then we get to the merits. And here, Justice Gorsuch, when Gorsuch is bad, he's terrible. When Gorsuch is good, he's awesome, right? He's like Jekyll and Hyde. In some cases, the guy's on fire. In other cases, he lighted the court on fire, right? Or maybe the state of Oklahoma. I mean, he basically torched half of Oklahoma and committed Indian country, right? But when Gorsuch is good, he's just great. I mean, of the three Trump judges, right? But Gorsuch, when he's good, he's good. And here he's really good. So Gorsuch explained compelled speech. We have the classic line from Justice Jackson in West Virginia Board of Education's reverse Barnett. If there's any fixed star in our constitutional constellation, the government cannot compel you to engage in ideas you don't agree with, prescribe what is orthodox, what is not. Just beautiful prose from Justice Jackson. The first Justice Jackson, Justice Howell Jackson, then Robert Jackson, now Ketanji Brown Smith, three Justice Jacksons. So just to be clear which one I'm talking about, probably no doubts, but we're talking about the Robert Jackson. I'm getting in trouble. Okay. It was Edmund Howell Jackson was in the 1800s, so we had three Justice Jacksons. And Gorsuch was saying that the idea that you can compel people to engage in this type of speech is extremely problematic, right? The designer does not want to endorse and give her talent to a gay wedding, and you should not be allowed to do it. The trick here, though, is public accommodations law. Was Piggy Park from Alabama? Piggy Park, the civil rights case. Anyway, there was actually a Civil Rights Act case from the 1960s, because you had Heart of Atlanta, you had Katzenbach. I know Katzenbach was from here, and the other case called Piggy Park. Piggy Park was actually a religious liberty challenge to the Civil Rights Act, where, if memory serves, a grocery store owner said, my religion does not allow me to serve black customers. That was the claim being made. So there's actually case law going back to the 60s saying, look, the First Amendment does not give you a carve-out to public accommodation laws. So in some regards, the 303 creative case was very significant because it created a First Amendment carve-out to public accommodation laws. Now, I think the flip side is the meaning of public accommodation has expanded significantly. Is a grocery store public accommodation? Yeah. A restaurant? Sure. Hotel? Yes. A custom website designer? I mean, that's not at least a common law what an accommodation even was, right? This was not a service open to everyone. These are custom services. But this case will have some impact, and I think it will spill over into other areas. Let's do religious accommodation. Groff versus DeJoy. I like this case. So you have Mr. Groff. He's a Christian. He doesn't want to work on Sundays. So he gets the ideal job. Postal service, right? They don't work on Sundays, right? So he's got the perfect job for him. But there's a problem. What's the problem? You all. Because you want your packages delivered on Sunday through Amazon. And the U.S. Postal Service said, okay, we'll use We'll give our workers to Amazon as private contractors. So they said to Mr. Groff, you have to work on Sunday. He says, no, I can't. This is my religion. Go ask someone else, pay an overtime shift, do something else. Don't do it for me. The Civil Rights Act, Title VII, seems to say that you have to accommodate religious practices unless it causes an undue hardship. Undue hardship, what does that mean? In a case from 77 called TWA versus Hardison, the court said, undue hardship means a de minimis burden, that even if there's the smallest burden, imagine Walmart has to pay one worker shift double wages. That's an undue burden for Walmart, a multi-billion-dollar company having to pay a few $100s for extra shift dollars. That was a precedent. Groff asked, overrule Hardison. Now, the court did not overrule Hardison, but they basically rewrote the precedent. I hate when they do this. They said, actually, all of you lower court judges, you are inferior. Don't forget that. You inferior judges, you've been misreading Hardison for 50 years. You idiots, right? We know how to read it. We'll tell you how to read it. He didn't call you idiots, but that was the upshot. The reason why is this was a 9-0 opinion. And they couldn't get the votes to overrule Hardison, so they said, we'll just rewrite it. And even though this was an Alito opinion, this has John Roberts' name all over it. I mean, Roberts had, this is a Roberts, maybe Kavanaugh, probably Roberts, sort of compromise. Pretend that this undue burden, this de minimis burden language was actually dicta. That the most important sentence of this case was actually a dicta. Who does this? If a lawsuit did this, I give them an F. This we get from the Supreme Court. By the way, law students, lazy. You call something dicta, that's the laziest thing you can do. That just means you haven't done your work, okay? That's the best you got, you don't have anything. But to the benefit, the court said Hardison has been interpreted wrong, and that the Postal Service has an accommodation as a duty to accommodate Mr. Groff, so he doesn't have to work on Sundays. This is good for workers everywhere. I think, if you have accommodation for disability, you have to build a ramp, equipment, that's expensive, there's cost. Religion should be treated on a similar level. All right, next up, Indian law. Halland versus Burkeen. Oh man, this case is a beast. My friends in the Fifth Circuit had like a 300-page en banc decision that just basically got ripped up. It didn't matter. Indian Child Welfare Act is a very complex statute, and it requires state courts place an Indian child with an Indian caretaker if one's available. Again, so if there's a custody dispute and the child, I'm going to exaggerate, has one drop of Indian blood, I'm only slightly exaggerating, the state has an obligation to check, is there some Indian family to take care of the child before the preferred foster parents? Even if it's a different tribe, right? Let's say the child is a descendant of the Navajo tribe, and you have a Cherokee people want to take over the kid. It doesn't matter. This turns domestic law to a domestic law. This turns domestic law on its head. All the best interests of the child standard, whatever law your state has, gets subjugated to putting it with the Indian family first. And as Justice Alito noted, I put this gently, the conditions on the reservations is not always ideal in terms of crime and economic disparities. Often the children might be better off not on a tribe, but you have this federal statute. The Fifth Circuit found that ICWA was unconstitutional under delegation grounds. They sort of split on equal protection, but it was a very complex decision. It gets to the Supreme Court. The court goes 7-2 with only Thomas and Alito in dissent, and Justice Barrett writes the majority opinion. Gorsuch is Indian law. You know where he's going. There was never a doubt in this one. So this one went 7-2. The Barrett decision, let me take a step back. I'm a law professor. I'm not a real lawyer. I just play one on TV, okay? Justice Barrett was never a lawyer either. She had zero practice experience. She was a law professor. So she approaches this as a law professor. In her mind, she thinks, okay, we have this big statute. What's the theory, right? Explain to me why is this unconstitutional? And if this is unconstitutional, what comes next? She wants me to see a law review article to explain why this behemoth intrusion on states' rights is invalid. Unsurprisingly, the lawyers didn't have a law review article for her. This is a very complex statute. They made some good arguments and precedent, but it wasn't enough. And in fact, Justice Barrett faulted the lawyers for Texas and the private plaintiffs for not giving enough. And so she says, sorry, no more, maintain the status quo. ICWA survives. But of course, Justice Kavanaugh writes concurrence. He always writes concurrence. He says, well, I'm going to rule for the Indians here, but there might be an issue that comes up in the future. isn't this perhaps maybe sort of a racial classification that you're treating Indians and non-Indians differently? And might that not violate the Equal Protection Clause of the 14th Amendment? In an appropriate case, let's consider it. So the issue's already teed up. It'll come back to the state court to see if Kavanaugh actually meant what he said. We'll see if he meant what he said in Moore v. Milligan. No, not Moore, Allen v. Milligan. We'll see if he meant what he said there. I don't think he did, but sorry. But we'll see. Whenever they say, we'll see what happens later, I just assume that they don't actually mean it, but we'll see. All right. Next up, civil procedure. Who likes CivPro? Come on. I love personal jurisdiction, international shoe. Do you remember this, right? I love CivPro, okay? So as I'm sure you remember, there are two basic kinds of jurisdiction: subject matter jurisdiction and personal jurisdiction, right? Subject matter jurisdiction might be diversity of citizenship or federal question, right? Is there a basis to be in federal court? And they have personal jurisdiction, the idea that do you actually have jurisdiction over the person? And the courts held that the Due Process Clause puts limits on personal jurisdiction. If I never enter a state, have no business there, you can't sue me there. Right now, if I fly through the state, the so-called tag jurisdiction, that might be permissible. Now it comes back to you all. Then we get to this case called Mallory. Mallory versus Norfolk Southern, the railroad. I'm going to simplify the facts just a little bit to make it easier. Norfolk Southern incorporated in Virginia. Plaintiff citizen of Virginia. Tort happens in Virginia. So it's a triple Virginia case. Where is a lawsuit filed? Philadelphia. Why they file in Philadelphia? Trial lawyers. They like it. It's a good forum, good jury, right? If you're a trial lawyer, you file where you think you have the best jury pool. The company says, wait a minute, we have railroads in Pennsylvania, but the tort happened in Virginia. Why is this suit in Pennsylvania? Excuse me. Pennsylvania had a weird law. It's an old law, been around for 100 years. And it basically says, if you do business in our state, which the railroad does, you must consent to personal jurisdiction. You must stipulate that you will receive process and be sued in our forum. Georgia has something similar, if memory serves. I think Georgia has something similar. It's a very rare law. There was actually a Georgia Supreme Court case in this that fizzled out on different grounds. And then Norfolk Southern said, fine, this statute is unconstitutional under the 14th Amendment. It goes to the Supreme Court, and you will get a split that you will never, ever see again, okay? So you have Justice Gorsuch, Justice Thomas, Justice Alito, and Jackson. Again, majority. Gorsuch, Thomas, Alito, Sotomayor, Jackson. That's your five-member majority. You'll never see that ever again, anything else. Who do you have in dissent? Barrett, Roberts, Kagan, and Kavanaugh. So that's like the dissent is like the law professor, people who love federal power. That's that, the Barrett, Roberts, Kagan, Kavanaugh. And then you have the majority, it's like, let's burn this down. You have the Gorsuch, Thomas, Alito, Sotomayor, Jackson crowd, right? So these are very different perceptions of federal power. And the majority was very fragmented because Alito only joined a very small bit. There had been some precedent called Pennsylvania Fire that said you can have these registration statutes. Alito said, that's not for me. Alito thought actually that this statute violates the Dormant Commerce Clause. That's a burden on interstate commerce, which he might be right about. The pork case, I don't have time to mention it, was this idea of can California regulate the types of pigs coming into their state? I don't eat pigs, so we didn't know, but apparently some pigs are treated poorly. Okay. The one thing about Alabama is everything has pork in it. So be very careful when I eat here, but everything else is good. We got chicken and fish for lunch. I'm good. Mississippi's worse. I have trouble eating there. The Barrett dissent was like, wait a minute. I love international shoe. I'm a law professor. I taught this for years. That can't be wrong, right? International shoe has to be the rule. Kagan, law professor. Shoe has to be right. So basically, Kagan and Barrett were being law professors. They taught procedure. So I'm not sure where this case actually goes. Because of the sort of fractured nature, I think Mallory probably still loses. All right, let me do one more case from this past term. Then it'll be 1 o'clock. I'll keep talking if you want to leave. That's fine. Do one more case from this past term, which is student loan debt. When they give this talk to a bunch of law students, they usually hate this case. Maybe you all feel better. I paid off my loans. Took me a decade. I felt very proud of doing it, but we also damn fool for doing it. I mean, why did I pay all this money for a loan? I could just be wiped out. As you recall, during the pandemic, lots of people were sort of out of work. They weren't making money and so on. So the Trump administration said, we're going to put a pause on federal student loans. We will not, there will not be interest accrued, there will be no penalties. We're just going to put a pause on these loans. Biden comes to office, he says, hold my beer. So not only did they pause the loans, Kavanaugh would like that line, right? Not only would they pause the not only would they pause the loans, the Biden administration would cancel them to the tune of $430 billion with a B, hundreds of billions of dollars of federal student debt. This is a significant amount of money. What's the statutory basis for canceling all of this debt? The HEROES Act. This was a law passed after 9/11, and the law basically says the secretary has the power, and there's the language, to waive or modify statutes during a national emergency. They had in mind 9/11, a terrorist attack, but Trump and actually Biden said, we can modify it because of the pandemic. It's an emergency. We can waive or modify the law. So just pause for a second. Can Congress give a secretary the power to waive or modify the law? Isn't that a non-delegation doctrine problem? Isn't the power to waive laws something that Congress ought to do? I think so. Trump did it. I was wrong when he did it. Biden did it. It's wrong when he did it. But the challenge in this case wasn't the merits. The challenge, as always, is what I'm doing right now, which is standing, right? How are you able to get into federal court? You need to claim an injury. The beauty of this policy is it doesn't impose an injury, it relieves an injury, right? Instead of paying your debt, you're not paying your debt. You're relieving a disability, a payment. So who the heck can claim an injury from having to pay less money? This is why the progressive policies are genius, because they're judgment proof, right? You can't get an injury. They're very slippery. DACA is not imposing a burden, it's relieving a burden. Okay. So one guy tried to bring a challenge. His name was fittingly Mr. Brown. So it's called Brown versus Department of Education. There's no sense of irony in the law. And Mr. Brown argued that, hey, wait a minute, I'm a student, a former student, but I didn't get relief, right? You gave all these other people relief, but my type of loans weren't relieved. So he brought basically an arbitrary and capricious challenge, saying that the failure to give me relief means that the policy was A and C, arbitrary and capricious, therefore set it aside. That lost 9-0. That wasn't even close. Alito wrote this with a very short opinion. He kind of got annoyed, saying that, no, you don't have some sort of entitlement to request a government handout, right? That's not what you go to federal court for. I think Alito is he's right on that point. The other case, though, worked. It involves MOHELA, no, not Mohalo, MOHELA, the Missouri Higher Education Loan Authority, MOHELA. This is an entity, and I'll just be a little bit vague, connected to the state of Missouri. And this organization processes student loans. And as I'm sure you know, when you process loans, you get fees, right? They're just origination fees and so on. So if these loans were canceled, MOHELA would stand to lose profit. And that's a classic pocketbook injury. In fact, the Solicitor General said if MOHELA brought this lawsuit, they would have standing. But MOHELA didn't bring the lawsuit. The lawsuit was brought by the by the Missouri Attorney General on behalf of MOHELA. MOHELA was very quiet. They didn't say a damn word about any of this because it's this quasi-state agency. They said nothing, no amicus, nothing. And so the SG argued that because it wasn't the entity itself that brought the suit, the Missouri Attorney General couldn't suffer an injury on behalf of the state. I have no idea about Missouri law. Maybe the Missouri AD next door knows about this, right? I just have no clue. I have no idea. John Roberts found a case that says there is a connection. Sure, why not? Again, when the chief wants to find standing, he'll find standing. It happens every time. But the major question, indeed the major question, the important issue here is the major question doctrine. This is something that just makes law professors tear their hair out apparent, most times, Jenny, I promise. And the question is, if Congress had intended to give the secretary this broad authority, wouldn't they have done so expressly or directly? Indeed, Congress considered bills that would have given this power, and they didn't pass student loan relief. So the court went 6-3, and they said that this is a violation of the major question doctrine. Justice Barrett, always a law professor, wrote a concurrence saying, well, I don't like the major question doctrine, separation of powers doctrine. That's the Gorsuch approach. I think of it as sort of a contextual canon, common sense. I'm not even sure. I don't think anyone agrees with her. I think she just wrote this, and I don't know if she made her feel better. I don't think anyone actually agrees with her on it. I'm not sure I agree with her on it. But at least there's 60 votes now to show major questions actually a valid canon. And I think we're going to have sort of a lot of, unfortunately, in the lower courts, arguments where everything's a major question. And if everything's a major question, then nothing's a major question. I would just be happy to bring back the non-delegation doctrine, saying, okay, you can't give the secretary the power to waive statutes. That's unconstitutional. Go home. Bye-bye. Adios. Or forget major question. But the court is just sort of skittish because of the New Deal. They're not willing to do this. All right. I'm going to pause here. If you need to go up, you may. Else I'll keep talking. I'll keep talking. Yeah, let me finish my spiel. I got a couple more minutes, then I'll go to Q&A. What's coming up? Actually, the term that began, happy first Monday. The term began this Monday. A couple big cases that are on the court's docket now. One which was argued Tuesday, which will not be big, unfortunately, involves the appropriations clause, right? CFPB versus Community Financial Services Association. Anyone do business with the CFPB? Any of your corporate lawyers? This is a behemoth of an organization. And it's been like in the courts my entire adult life. It seems like since like 2009 or 10, everything is about this agency and just will not die. It's like the hydrant, cut up one head and they keep just growing back, right? The latest challenge comes from my beloved Fifth Circuit, which involves the appropriations clause. And the way this agency is structured is very unique. It doesn't actually ask Congress for an annual appropriation. Instead, it makes a request to the Federal Reserve, and they can request up to $700 million a year, more or less, and they get it. They don't have to justify it. They say this is reasonable, that's enough. Congress has no control over the budget. The only way Congress can control the budget of the CFPB is by passing a statute over the president's veto and modifying the structure. So basically, in perpetuity, this agency will fund itself. And not only that, at the end of the year, if they have overage, more money they spent, they can keep it. No agency has that. And more, they can invest it. They can basically invest their money. So this is like just a in perpetuity agency that cannot be subject to any sort of congressional oversight. All right? The Fifth Circuit said this is unconstitutional, that this double insulation, that they get money from the Federal Reserve, the Federal Reserve is insulated from Congress, makes it unconstitutional. My good friend Noel Francisco argued this case on Tuesday. It did not go well for him. I think he's going to lose 6-3 or 7-2. Barrett and Kavanaugh are like, this is not a thing. The courts don't scrutinize appropriations. There is a cap. It's about $700 million. That's good enough for us. So this could have been a huge separation of powers case. I don't think we'll get more than 2 votes. Even Alito was sort of on the fence. So I think this one goes 7-2, maybe 6-3. We'll see what happens. Another big case, Loper Bright Enterprises versus Raimondo. This is the Chevron case, right? What's Chevron? No, not the gas station. This is the admin law doctrine. Do they have Chevron gas stations in Alabama? Okay, good. They're not everywhere. They don't have them everywhere. Okay, so what's Chevron? Well, at its most basic level, there was a case by Justice Stevens in the early 1980s that said, if there is some statute that's ambiguous and you have an agency regulation that interprets this statute, we'll defer. And it wasn't meant to be this huge separation of powers doctrine, sort of just a common sense thing saying, look, if you have expert agencies and we're not sure what the statute means, we'll defer. But over the years, Chevron has sort of metastasized into this entire doctrine that empowers agencies to go rogue. And whenever an agency goes rogue, oh, well, Chevron, we can't second guess what this agency is because they're the expert, yada, yada, yada. So this goes on and on. Will the court overrule the Chevron doctrine? I don't think they will. They'll just do what they always say. Well, we're not going to overrule it. We'll just rewrite it. Pretend it's always been different. You know, the world is not as you knew. You're all just a bunch of idiots who've been reading our case wrong for 50 years, like in Groff. It kind of annoys me because lower court judges and litigants, they're trying to do their level best. They get a Supreme Court case, they read it, they do the best they can. The court says, just kidding, here's what it really means. I think it's somewhat disingenuous. It sort of annoys me, but what do I know? First Amendment, this involves social media. O'Connor Radcliffe versus Garnier. This happens everywhere. Public officials have Facebook pages, they have Twitter pages, X pages, excrement, whatever you want to call it, right? And they have constituents who bombard them with comments and negative attention. And so what do public officials do when you get negative social media comments? Block. They block their constituents. And depending how the social media works, you can't see the postings, you can't reply, and so on. You can't put little poop emojis on, the the page and so on. Is this state action? What's important here is that whenever a public official has a Facebook page, it's usually created as part of a campaign. They're running for office, they have a Facebook page. It's not done pursuant to any government authority. There's no statute or regulation saying that's part of your job, you must do this. The school board members in this case have argued that because they're not acting pursuant to any governmental duty, it cannot be state action. Of course, this involved President Trump a couple of years ago because he blocked everyone on Twitter who criticized him, and they argue that this is not state action. The case sort of just pettered out, though, because he lost office, as they say. All right, Second Amendment. My goodness, the court went a decade without deciding a gun case, but now we are back to back. Last year we had Bruin, which held that the right to bear arms extends outside the home, and almost immediately after Bruin, the lower court said, okay, what the heck do we do now? Right? What do we do now? This test from Justice Thomas, this historical analogy test, what do we do with it? So the Fifth Circuit said, hold my beer, as they say. So we got United States against Rahimi, R-A-H-I-M-I. This is a guy you do not want to be the poster child of the Second Amendment. He beat up his girlfriend and shot at several people in the span of a week. Right? This is a bad dude. A domestic violence restraining order, DVRO, was entered against the guy because he's a bad guy. Then he was busted with having a firearm. He initially pled guilty, but after Bruin, he sort of challenged the basis of the guilty plea. And the question here is whether 922G, this is the federal gun statute, prohibits the possession of firearms by persons subject to DVROs, restraining orders. Does that violate the Second Amendment? Fifth Circuit said no. And if you think of historical analogies, there were no domestic violence restraining orders in the 1860s or the 1790s. That wasn't a thing. In fact, domestic violence was allowed. You could beat your wife. That was permitted in the rule of thumb. You were allowed to beat your wife with a stick no wider than the thumb. And so the idea that there's a tradition of banning people who engage in domestic violence, shaking his head, the idea that you can ban people who engage in domestic violence without a conviction is not strongly supported. So perhaps under the Bruin test, I think the Fifth Circuit probably got it right. But I think what this might illustrate is the court doesn't actually support the Bruin test. And I think we're going to have some sort of serious second thoughts. Justice Kavanaugh will just, the Homer Simpson meme just sort of walks backwards into the bush. He'll just vanish on this one. We don't talk about Bruin. I'd give you the tell-free law review note, right? They're going to just back off. And I think Thomas is going to lose the majority in that one. They're going to say, well, we didn't mean it. Justice Barrett had an opinion from the Seventh Circuit about a guy named Ricky Cantor, who engaged, was it Medicaid or Medicare fraud? I can't remember. Someone who does Medicare fraud, they can have a gun. They're not dangerous. Rahimi, dangerous, bad, no gun, right? That'll be the holding. So I can give you the holding on 1 second. Last case, which involves a case from your circuit that got granted a couple days ago, Moody versus Net Choices, and actually a companion case from Texas. Paxton, the not impeached, or impeached but not convicted, Attorney General, also versus Net Choices. Your state and my Florida and my home state enacted a law that restricts social media. And the laws are sort of complex, but one of the components is the companies sort of explain their moderation policies. And if they exclude someone or they ban someone, they must explain why. This is a very big First Amendment case, which the SG, I was actually surprised, told the court to take this case also. So it's to what extent are social media companies sort of like public utilities that can be regulated? Are they engaging in commercial speech? Or is this a violation of compelled speech? Does a social media company stand in the same position as the baker or the website designer just want to make the cake? This is a very significant case. I don't know which way it's going to come out, actually. I'm actually sort of mixed. Thomas and Alito have been very critical of this. We'll see where Gorsuch is. I think Kavanaugh may actually be sympathetic to this, but I'm not positive. All right, 10 minutes over. I'm done. Thank you all so much. Now I welcome your questions. Thank you.
One is please fill, Josh is saying to take questions. Please fill out the evaluation forms. You can just leave them on the table or put them back on the registration table. And also, please turn in your badges before you leave.
Thank you.
Josh, thank you.
Thank you. All right, I'm happy to take your questions. I think you're up first in the queue.
Isn't there a South Carolina voting rights act case on this year?
Oh, I didn't do that one. It's Alexander. Oh God, I can't remember. Yeah, it's not in my notes, but there was one, and I'm blanking on the facts. Was that about intent? Was the South Carolina intentional discrimination? What does intentional mean on Section 2? I don't remember, I'm sorry. But it is on the docket.
You could ask the speculative about issues just now, talk about a particular mission that brings together a lot of aspects from several of the cases you're talking about. And it's linked familiar with the Michigan Supreme Court, gives us about 5 to 10 years vote. That's very well made final proposed rule that all 50 state judges were compelled to use the preferred pronouns when in the park.
Yes.
And this got a lot of pushback. I've actually spoken to some of these Michigan judges. One intermediate appellate judge said, I'm not going to be compelled to participate in this delusion. And so you have a lot of this going on where they said, well, one judge said, if it's a man, and you're making me call the main key, you ask to tell me about it.
Yeah.
I think it's a fascinating issue that's going to involve a lot of different parts. What do you have any thoughts on that?
Okay, so if you couldn't hear the question, I'll repeat it. And there's a little bit of noise coming from the door. The SEC guys are making some rowdy stuff outside. The Michigan Supreme Court put out a rule which applies to litigants and judges alike in the state. And the rule is framed in such an obtuse way, but I'll just summarize it. You may have an obligation to use the person's preferred pronouns. Now, if a person says, I want you to call me Mr., you can't call this person Mrs., right? You have to use the pronoun that they wish. There were 2 dissenting opinions from Justice Viviano and, I can't remember the other one's name, but there were 2 dissenting opinions. What's the other one? Zara, thank you, yeah. Thank you, AJ. So there were 2 dissenting opinions, and they raised the compelled speech issue. This issue has come up in the context of professors. There was a 6th Circuit opinion, I think it was by Judge Tapar, basically saying that this is compelled speech. You can't make a teacher force them to say something you think is wrong. And to say a person's a Mr. when they're Mrs. is something that's wrong. Was there 11th Circuit opinion this also? Am I blanking? And there was a 6th Circuit opinion. I think the 4th Circuit went the other way. I might be blanking on this. The court will probably have to take this at some point, and they're not going to want to. And I think just one of the tells, if you read Justice Barrett's opinion, I don't know which case it was, but Barrett actually gave an opinion recently which used the word cisgender. She used the word. That's a word. You can use it, but that sort of signals where you are. Justice Gorsuch, my goodness, wrote the Bostock decision. He uses words like cisgender. If you read the Alito dissent very carefully, Alito never refers to Bostock with any gender, just go use Bostock. Kavanaugh basically used the preferred pronouns of the defendant. So I don't know if there's any more than 2 or 3 votes in this at the court. So this is one of these cases where maybe better to keep away from the Supreme Court. I think you lose. It's a very tricky issue. I think you lose Barrett, Kavanaugh, and Gorsuch in this issue. You'll 0 for 3 with the Trump judges. AJ?
So on the 303 creative issue of standing, can't you do like a pre-enforcement review? Like, isn't that how a lot of civil rights?
Yeah, the irony, right?
60s?
Yeah, the irony, the NAACP made an entire movement on pre-enforcement challenges, and yet the left complains that the Colorado Baker and the Colorado website designers can't do it. Yeah, I think there's basis for pre-enforcement challenges. I don't think it's terribly problematic, but people seem to say that it's too premature, that there's no basis in any prosecution. Another case is called Laufer versus Atchison Hotel about so-called civil rights testers. We had this woman who had a disability. This was her racket. I will use the word racket deliberately. This is her racket. She would go to a website of a hotel she had no intent to visit, call them and say, do you have accommodation for disability? I mean, they basically didn't have it. She would check their website, and then she would sue them. Again, she sues hotels which don't have accommodations on their websites, even though she has no intent of ever going there. And actually, this got to the Supreme Court. They granted cert, and she said, never mind, I want to withdraw my case. And in fact, the Chief Justice said, come on, we can't be manipulating our docket. But if you can have these tester cases where people sue without any intent of ever actually using this business, I think you can have the case with the baker and the website designer. It doesn't terribly bother me, but people are bothered by it.
What do you think of the application of the disparate impact doctrine to the affirmative action situation at colleges?
More specifically, what do you mean?
Disparate impact where you analyze statistics and prove discrimination without the existence of evidence. So in other words, even if they don't put it in writing, but 5 years from now, lo and behold, you have exactly the same numbers that you have.
I think it's going to be tricky, right? In other words, the university said, we cannot keep our minority numbers the same unless we have these policies. And let's say in 5 years, lo and behold, their numbers are exactly the same. So that can mean they're cheating, or it can mean these policies were never needed in the first place. I'm not a fan of disparate impact. I think conservatives should not wield it very gladly.
I wrote regulation to do it. So
Oh, okay, maybe they should, but I think, look, let me put it this way. If there's a Republican administration, which may never happen ever again in my lifetime, but if there is one, sorry, if there is one, the Department of Education can go wild on this one and ask for records and ask for documents, even in the absence of litigation. We'll see if it comes up.
So Glock versus Detroit plainly overruled Parsons. The Harvard case clearly overruled Greer. What politically is going on that's causing them to say, we're not really overruling it, we're just kind of explaining.
John Roberts. Don't get me started on the Roberts. Judge Pryor left, so I'll be maybe a little meaner. Right. The Chief Justice wants to say, look, we're not overruling precedent. We are standing by the Warren Court. We're standing by the Byrd Court. Just all of you idiot lower court judges have been wrong all these years. No one's buying it, right? The Chief Justice's charade depends on people being idiots. But anyone with a pulse can see what they're doing. It's not straightforward. I don't like it, but they've been doing this now for a while. This is why you have all these numbers. What percentage of doctrines overruled? It's a meaningless number because court just rewrites precedent all the time. I don't like it. Yeah, Gruder's overruled, Baki's overruled, Lemon's overruled. They actually overruled Roe altogether. Roberts not showing that opinion. Meanwhile, Roberts would overruled Roe and Casey without saying it. He said, no, we will make up a new standard. Say this is what Casey said all along. He does this every time. It's so predictable.
All right, I have a picture on the spot question. You can evade it. Who's your favorite justice?
Oh, Thomas, that's not a hard one. That's actually not a hard question. I mean, I am partial to Alito at some points. I think Alito can be extremely effective, but just in terms of first principles, Thomas just can't be beat. The other three Trump appointees, I don't know. If you combine them to one person, they would make a good justice, but individually they have all these flaws that I don't like. Okay, what else? Yes, sir.
I was listening to a podcast and an interview for an author who took the position that President Donald Trump was disqualified under Section 3 of the 14th Amendment for holding office. And you were mentioned as someone who had taken an opposing view.
Did I?
I'm not asking about the merits of that. I'm asking how likely do you think that issue would come before the Supreme Court?
The question was about our favorite new obscure provision. So it used to be emoluments clause. Now it's the insurrection clause. It's like they just pull out obscure provisions to try and stop Trump. It's the same script, different page. Look, I wrote a 130-something page paper on Section 3 and insurrection with Seth Barrett-Tillman. I don't have time to talk about it now. I think there is a 0% chance the court knocks Trump off the ballot. I think it just doesn't happen. I hope we never get to the Supreme Court, but if there's one rogue state Supreme Court, Wisconsin, right, that decides to disqualify Trump in a purple swing state, it goes to the Supreme Court right away, and I'll be there. Did I say Wisconsin? I'm sorry. But yeah, I'm not saying Wisconsin. I'm saying Wisconsin. All right.
Why not 101 cases everyone should know?
It's actually 112. We added a number of cases for the second edition, but didn't change the title because it's it. So actually, if you look at the title, it's 100 plus cases. So that's how we got around it. There were actually never 100. There was always 103. So we kind of just 100 is close enough. Maybe one more question. Yes, sir.
I was hoping that Judge Pryor would still be here for this question, but virtually every circuit except for the Fifth Circuit and most district courts throughout the country have stayed pending Second Amendment litigation in light of the Reagan case. I think personally the Reagan case is going to be a very narrow decision. I don't think it's really going to, overturn the apple cart, so to speak, with Bruin. But I'm curious, what do you think in terms of reading the leadings on how that pans out and what the trickle down effect to all of these timid lower courts waiting for something to happen?
For a decade, the lower courts resisted Heller and McDonald, and the Supreme Court did nothing to stop them. The lower court said, oh, we will apply heightened scrutiny, which basically means the government wins in every case, right? We just saw in every case. Bruin didn't change that. The judges still don't like guns. And in fact, you have people like Judge Carlton Reeves in Mississippi and otherwise who say, oh, we're going to have all these expert witnesses and these PhDs testifying. Tom, you don't need this. It's law. It's not history. We're not doing expert reports on Dauber and on historians, right? So what does that actually mean? What does this take away? I think, unfortunately, Kavanaugh and Barrett are going to run away from Rahimi, and we may not get a 5-member majority. We'll get something fractured, which will just put the Second Amendment in disarray. A lot of advocates are very much afraid of this case. They want to go away, to dismiss the case. I don't know what's going to happen. The person arguing is a federal defender. He's not a Second Amendment advocate. His interest is helping his client, which is, of course, his interest. His interest is also in helping the defense bar, which is, of course, that's his interest. It's not about helping Second Amendment advocates elsewhere. So I think the government didn't even seek en banc for him. They didn't waste their time. This is the case they want with the domestic violence guy. There are other cases in the pipeline the court may grant. They may say, well, Rahimi loses, but the guy on Medicaid fraud wins. That would be a non-terrible split, but it's just going to be a long-term for gun advocates. I don't know what the court's going to do. It'll be ugly. All right. Thank you all so much. Thank you. Thank you.